A big case before the United States Supreme Court today. An opinion released, Murthy v. Missouri. In a 6-3 decision, the justice is saying the plaintiffs don't have standing to challenge the federal government's many abuses of the First Amendment. In fact, the 6 justices seem to think that, well, they didn't really prove that it was the federal government that violated the First Amendment. That's not how Justice Samuel Alito or Justice Thomas or Justice Gorsuch feel. They wrote the dissent today, and they were just absolutely scathing. They said that the court today shirks their duty and thus permits the successful campaign of coercion in this case to stand as an attractive model for future officials who want to control what the people say, hear, and think. This is regrettable. What the officials did in this case was more subtle than the ham-handed censorship found to be unconstitutional in Volo, a different case, but it was no less coercive. And because of the perpetrator's high positions, it was even more dangerous. It was blatantly unconstitutional, and the country may come to regret the court's failure to say so. Officials who read today's decision, together with Volo, will get the message. If a coercive campaign is carried out with enough sophistication, it may get by. That is not a message this court should send. It's a big deal. Let's bring in a lawyer for one of the plaintiffs. Mark Chenoweth is here, President and Chief Legal Officer for the New Civil Liberties Alliance. Sir, good to have you on the program today.
Great to be with you, Vince. Thanks for having me.
Mark, give me your reaction to today's news as 6 of the justices say that your plaintiffs don't have standing.
Yeah, it's very disappointing, Vince, and it's a little bit of liberty died today. This is not a result that the American people can live with in the long run. Now, if I were trying to minimize it a little bit, I'd say, look, they were only talking about standing for the preliminary injunction in the case. They haven't said that there's no standing for the underlying case. So what that means is because an injunction would have future relief, they're saying that there wasn't the standing in order to show that future relief. The good news is 3 justices on the court found not just standing, but also ruled with us on the merits that the federal government was in violation of the First Amendment. The other 6 justices didn't reach that question. So at least they aren't blessing the government's conduct, but they're sure making it awfully difficult to hold the government's feet to the fire.
One of the things that stands out to me is it seemed to me, just giving, as a layman, reading through the majority opinion, that they didn't think there was any pressing concern right now to deal with this issue that could harm any of these plaintiffs. But I kept thinking, wait a second. We're in the midst of the presidential election. If there's ever been a time to be urgently concerned about Americans having their communications restricted, it's at this very moment, isn't it?
Absolutely right. And this gives a roadmap for censorship. And look, our clients that we were representing here were being censored over what they said about COVID. There were other folks in the litigation who we do not represent at NCLA who were concerned about some of the misinformation that they were allegedly being held responsible for in the run-up to the 2020 race. And when I say allegedly, they were saying things like the Hunter Biden laptop was true, and they were being censored for that, right? And so there very much are election consequences for how the government can behave this fall and how much more difficult it will be to hold them responsible for government misinformation, which is what we're all, I think, particularly concerned about.
You know, on the issue of COVID in particular, Justice Alito focuses on that at some length in his dissent today. He points to a White House official called Rob Flaherty, the White House Director of Digital Strategy, and his emails to Facebook, including a subject line that said...
By the way, a top official in the Biden campaign, by the way, now, Mr. Flaherty is.
Yeah, so the issue is ongoing here. His behavior includes sending a threatening email to Facebook saying, "You're hiding the ball." He said he was, quote, gravely concerned that Facebook is one of the top drivers of vaccine hesitancy. He demanded to know how Facebook was trying to solve the problem. In his words, quote, "We want to know that you're trying. We want to know how we can help. And we want to know that you're not playing a shell game with us when we ask you what is going on." The communications continue here, only becoming more and more threatening as the White House tries to browbeat Facebook into submission into censoring content about COVID, including targeting at one point a segment by Tucker Carlson, at the time a host on the Fox News channel, questioning the efficacy of the Johnson & Johnson vaccine. The White House was able to induce Facebook into suppressing the reach of that video to prevent it from being seen by a broader audience. This seems to me, Mark Chenoweth, as clear as it gets when it comes to the government using Facebook as a cutout in order to imperil First Amendment rights.
That's exactly right. The government was using a third party to shut down speech that was inconsistent with the government narrative, and that is directly violative of the First Amendment. The majority really glosses over the fact that so much of the speech that was suppressed that our clients engaged in, our clients are prominent doctors at Harvard and Stanford medical schools, for starters, right? They were, much of the speech that they engaged in was truthful speech. They were the ones taking issue with different things that the government was saying about natural immunity not really existing, or the government was overselling the efficacy of the vaccine, saying, for example, that at one point you couldn't get COVID if you had the vaccine, which wasn't true. That was never true. But the government was preaching that at one point. And when our folks were pushing back against the government's false narrative, they were getting censored at the behest of the government.
In the majority opinion today, there's a claim that that one of the arguments that the plaintiffs are making in this case, your clients, are, quote, unpersuasive because they argue that they suffer, quote, continuing present adverse effects from their past restrictions, as they must now self-censor on social media. But the plaintiffs cannot manufacture standing merely by inflicting harm on themselves based on their fears of hypothetical future harm that is not certainly impending. So when I read this little section of the majority opinion, Mark, what I'm hearing is that if you know that there's a government threat to your ability to speak, and there's a looming threat that's going to censor you, and it leads to a chilling effect in that you don't express views because you're concerned that you're going to be banished from expressing other views going forward, that's a First Amendment violation. How can the justices not recognize that?
The dissent was all over this. They said that the majority was creating new standards in the decision today, and I think that's exactly right. You hit on it. Usually, if your speech has been chilled, that's a First Amendment violation. Here they're saying, well, you can't manufacture standing on that basis. But wait a minute. What the government was doing was taking advantage of the fact that our clients had accounts on Facebook and Twitter and other social media platforms that were valuable to them. They had followers. They had built up groups of followers that they didn't want to lose. And by the government using these platforms to coerce our clients and to shut down their speech and threaten them, they were using the threat of being deplatformed, of losing access to their audiences as a sort of backstop for to stop saying things that the government didn't want them to say. So that's absolutely what you said, Vince. That is chilling their speech, and it's using these third parties to do it, and that is absolutely violative of the First Amendment.
Mark, how much control does the government, in your view, certainly having gone through this and looked at all the facts, how much control does the government wield over these social media companies, as you understand it?
Well, I think anybody who wants to know the answer to that should read the Alito dissent, because he goes into great detail and does a very nice job with respect to one of the platforms, which is Facebook. He marshaled a lot of the best evidence about what was happening to Facebook, including their need to rely on the government to push back against some of the European Union regulation, and how that really put the whip hand in, with the White House over them, and that's why their responses to White House demands are so subservient.
Yes.
And the fact that the majority treats Facebook as, well, they didn't accede to everything that the White House said. Vince, they changed their policies on a routine basis in response to demands from the White House that they do so. And our clients were then censored as a result of those changes in policy.
And you can see in the communications, you mentioned it, they're subservient, they're groveling. The Facebook is crawling across the floor on their hands and knees in order to suck up to the Biden administration. And that detail that you just brought up, that Alito brought up in his dissent today, is one that I hadn't contemplated before. We often talk about Section 230, all these protections that these social media companies have, and the looming threat that the government is going to come in and strip those protections away. The other piece
also
is
true.
Yeah, that is true. But the other piece is that these companies have business in other countries. And when they square off with those countries, they're hoping that the federal government is going to stand up for them. That's an important element here. And the Biden administration implicitly leaving them with the impression, we're not going to be there for you unless you carry out our propaganda.
That's right. Play ball with us and be part of the censorship industrial complex, or we're not going to be there for you in pushing back against European regulation that's unfair to you, on whether it's on data privacy or whatever else.
It's remarkable. So you mentioned some glimmer of hope here. What is ahead for us? Is there still a chance for a victory for the First Amendment?
Well, there's a glimmer of hope. I mean, I will say this. If the court was going to make this ruling on standing, it should have let the attorneys for Jill Hines and the other individual plaintiffs stand up and speak to the court. In the court, they let the Solicitor General of Louisiana speak. We asked for separate argument time, and we didn't get it. And they asked questions about standing to the Solicitor General of Louisiana. He was not the person in the best position to speak to the standing for the individual plaintiffs, including Jill Hines. If they were going to issue a decision on this basis, they should have heard directly from Jill Hines' attorneys, not just from the state of Louisiana. But having made that mistake, they're now sending the case back to the lower courts. The preliminary injunction is dead, but the whole case isn't. We'll have the opportunity to try to salvage something here, but they have made it very difficult. They've really created a very small needle that you have to thread in order to show the level of traceability and redressability that they say that you're going to need to have. And I think if this 20,000-page record, Vince, wasn't enough for someone to show that they met the tests that the government is laying out here, how is any ordinary American who's getting censored on Facebook or Twitter in the future ever supposed to be able to stand up and assert their First Amendment rights? They've I think, deliberately created a very high barrier to the ordinary American being able to vindicate their First Amendment rights.
And it allows the government to distort the public consciousness away from reality, which continues.
That's right.
Thank you very much, Mark Chenoweth. Thank you for your time today and your role in this fight. Really appreciate you, sir.
Thank you. NCLAlegal.org if people want to learn more.
NCLAlegal.org.